Hello. Good evening, students. I am Rohit, and today we have to start with the powers and functions of the president. Okay. So in the last class, we have completed the removal of the president and vice president, and today we have to start with the powers and functions of the president. Now remember, under Article 53, the first provision says that all the executive power of the union is vested in the president. Okay, so all the powers of the union government, I mean all the executive powers of the union government are vested in the president. Now, if we categorize the powers of president, then we can categorize into 7 parts. Okay, so the powers of the president can be divided into 7 broad categories. The first power of the president is the executive power. So broadly speaking, president has 7 types of power. The first power is executive power. For example, president appointing the prime minister, president appointing any other authority can be considered as an executive power. In fact, president pardoning a convict is also considered as the executive power of the president. Many might think that the pardoning power of the president is the judicial power of the president, but no. Pardoning power of the president is the executive power. Okay. So, executive power covers appointment of the prime minister, ministers, CAG, election commission members, pardoning power. These all considered as executive power. Now, the second power of the president is legislative power. In legislative power, what all comes? For example, president has the power to dissolve Lok Sabha is an example of legislative power. The president can issue an ordinance during the recess of parliament is also again an example of legislative power. Then the president can summon the parliament, president can prorogue the parliament. These all can be considered as legislative power of the president. A bill passed by the Lok Sabha and Rajya Sabha becomes a law only when it receives the assent of the president. So the president's the president's signature is important for any bill to become an act. So that is also considered as its legislative power. Now the third is judicial power. So president appointing judges of Supreme Court can be considered as judicial power of the president. Then fourth, financial power. Under financial power, you can simply say the president appoints finance commission after every 5 years. That can be called as financial power of the president. The president recommendation is required for the introduction of money bill. I mean, while studying money bill under Article 110, under Article 110, the money bill can be introduced in the Lok Sabha only on the recommendation of the president. So money bill requires the recommendation of president is an example of financial power. President appoints finance commission after every 5 years is an example of financial power. Now fifth, military powers. Military powers. Now remember, we have already discussed this particular point in Article 53 Clause 2. According to Article 53 Clause 2, the president is the supreme commander of defense forces of India. So that is the military power. But these all powers are nominal in nature because the real power is with the prime minister and the council of ministers. So when I am saying the president is the supreme commander of defense forces, so it doesn't mean that the president has the authority to give the permission to the defense forces to attack any other country. No, the president, despite being the supreme commander of defense forces, doesn't have the power to give the authority to the defense forces to attack any other country. All these war are subject to the approval of the government, that is parliament and the prime minister, not the president. It is only for the nominal. Now sixth, after military power, it is the emergency power, and we have already completed the topic emergency. We all know under emergency provision, the president can the president can impose 3 types of emergency, which we have already discussed under the separate chapter. After emergency power, it is the financial power. Okay, so all the foreign agreements and all are done in the name of president. So it is the it has to be diplomatic power, not the financial power. Okay, so under diplomatic powers, to send the ambassadors, to receive the ambassadors. Okay, so all these things are done in the name of president. Okay, so president is the main authority. So the powers of the president can be divided into 7 broad categories, but today we are not going to understand. Okay, Today we are not going to understand each and every power, because all these powers will be discussed when the time will come. For example, the legislative powers will be discussed in the ordinance power of the president, and when we will be studying the parliament. So in the parliament, we will be studying that what will be the legislative power of the president. So whenever the president dissolves the Lok Sabha, we can call it as the legislative power of the president. So all these powers will be discussed in the separate chapter, but not today. Today we are going to discuss only the three important powers of the president, which cannot be covered in any other chapter. These three powers of the president are: first is the veto power of the president. Again, veto power is the legislative power of the president. Second is the ordinance power of the president, that is also legislative power. And the third is pardoning power of the president, which is the executive power. So today we will be completing only those topics or those powers which cannot be covered in any other chapter. For example, president appointing the prime minister of India, that is the executive power of the president, but this particular point will be discussed in the separate chapter, that is prime minister. So all the powers will be discussed separately. For example, we discussed emergency powers of the president under the separate chapter, emergency provisions. Okay, so today we are going to start with only three powers of the president, and today we will study these three powers. The first power is the veto power of the president. The second power is the ordinance making power of the president, and third is pardoning power of the president. So today we are going to complete these three powers of the president. So first we will start with the veto power of the president. Okay. So and remember, this particular topic is important for examination. See, president in general is important for examination, and out of all the powers of the president, these three powers are super important for examination. So I want that you should, you should stay focused. Okay, while studying. So now first we will start with the veto power of the president. The first is the veto power of the president. Now, before I start with the veto power of the president, first of all, let us understand what is the meaning of the word veto. The word veto means to forbid. Okay. Veto means to forbid, or in simple words, to say no. Now the question is, why the president is trying to say no? And president is saying no to what? So all these questions should be answered under this topic, veto power of the president. But right now we have the idea that why, but right now we have the idea that what is the meaning of the word veto, and it is to stop something, to forbid something. And now how we will understand this particular topic? See, for this we have to understand Article 111. Okay, in order to understand what is the veto power of the president, for this we have to understand what is Article 111. Okay, now we all know Parliament consists of Lok Sabha, Rajya Sabha, and the President of India. And one of the main function of the Parliament is to make laws, because Parliament is the legislative organ of the central government. Being a legislative organ of the central government, the primary function of the parliament is to make laws. And for making any law, these three, approval of these three is required. So remember, if parliament wants to make a law, then for this, first of all, we need to introduce a bill. Bill is a proposal for legislation. So if parliament wants to make a law, then first of all, it has to introduce a bill. Okay, what is a bill? Bill is a proposal for law. Once this bill is passed from both the houses of parliament, it will be sent to the president. Now, without the assent of the president, no bill can become a law or act. Only when it receives the assent of the president, then that bill can be called as a law. So I hope this particular point is clear, that the primary function of parliament is to make laws, and for making a law, the approval of Lok Sabha, Rajya Sabha and president is required. And to initiate the procedure, first we have to introduce a proposal for making the law, and the proposal for making the law is called as bill. So bill is a proposal for legislation. Once the bill is passed from both the houses of parliament, it goes to the president for the assent. Now remember, under Article 111, it is mentioned that how many options does the president have? Okay, so when a bill is sent to the president, what all options president have? These options are discussed under Article 111, and under Article 111, the president has three options. The first option with the president is that the president gives his assent to the bill. See, if a bill is sent to the president, then the president can either give his assent to the bill. I mean, the president can give his signature. So suppose if president give his signature to the bill, then we can call this bill as act. So a bill can become an act only when it receives the assent of the president. But suppose president says no. President has withheld his assent to the bill. So the second option under Article 111 is that the president saying no to the bill. President said that I am not going to sign. It means president has withheld his assent to the bill. Here assent means to give his approval. So president gave his assent to the bill. It means president has given his signature. To withhold his assent means the president has said no to the bill. When president says no, it means the bill will end. So when bill ends, only when the president says no to the bill. And whenever president is saying no to the bill, this particular power of the president is called as absolute veto. So absolute veto means when the president exercises the second option, and the second option under Article 111 is the president withholding his assent to the bill. President straight away said that I am not going to give my signature to this bill. So absolute veto means president withhold his assent to the bill. So if I say the president exercised absolute veto on this particular bill, you understand that president has said no, and with the application of absolute veto, the bill ends. Now, what is the third option under Article 111? The third option under Article 111 is to return the bill. So, all these three options are, the first option is to give his assent, the second option under Article 111 is to withhold his assent, and the third option is to return the bill for reconsideration of the parliament. Now, suppose parliament has passed a bill and president wants that this bill should be reconsidered by both the house of parliament. So, whenever president returns a bill once, this bill will be again reconsidered by the Lok Sabha and Rajya Sabha. Now suppose they pass the bill again. The same bill has been passed again by the Lok Sabha and Rajya Sabha without any changes or with changes. It doesn't matter. If the president has returned a bill once, then it is the job of the Lok Sabha and Rajya Sabha to reconsider that bill. Now suppose Lok Sabha and Rajya Sabha passed the same bill without any changes or with changes. It doesn't matter. It is irrelevant whether the changes have been introduced in the bill or not during the second instance. But if both the houses have passed the bill with or without amendment, then it again goes to the president, and now president under the constitution is bound to give his assent to the bill. It means president can return a bill only once. In the second instance, president is bound to give his assent to the bill. And suppose president says no, I mean, according to constitution, the president can return a bill only once. But what happens when the president returns the bill once again? Remember, this will be called as violation of the constitution, because under Article 111, the president can return a bill only once. If the president tries to return the bill in the second time, then it will be considered as violation of the constitution, and for this we can remove the president from the office. So the president is bound to give his assent in the second instance. And in this case, the president has to give his signature. So it means now the president's veto power is suspended. So we can call this particular power as suspensive veto. So suspensive veto means when the president has returned a bill once, in the second instance, the president must give his signature to the bill. Now the veto power of the president stands suspended. Now he cannot exercise his veto power on the bill. Now you must give your signature on that bill. So that is the suspensive power of the, that is the suspensive veto of the president. So I hope you understood the difference between the absolute veto and suspensive veto. So when I say absolute veto means when the president withhold his assent to the bill. It means president is saying that I am not going to give my signature to this bill. First, this suspensive veto means here the veto power of the president is suspended. And why it is suspended? It will be suspended only when the president has returned a bill once. And in the second instance, he is bound to give his signature to the bill. So he can return any bill only once. But remember, here is a catch. And the catch is the president cannot return a money bill. I mean, I am discussing about the normal bill. President has the authority to return a bill, but only when it is a normal bill. When it comes to money bill, the president cannot return a money bill. And there is one more kind of bill that is called as constitutional amendment bill. So on the constitutional amendment bill, the president is bound to give his signature. He is bound to give his assent on constitutional amendment bill. He cannot say no and he cannot return the bill. And whereas money bill is concerned, he can say no on the money bill, but he cannot return the money bill. Okay, so when it comes to money bill, president cannot exercise suspensive veto. And when it comes to constitutional amendment bill, the president can exercise only one veto. And I mean, the president cannot exercise any veto. The president must give his assent to such a bill. Okay, so I think we are done with two veto, absolute veto and suspensive veto. Now what is the third veto? See, in order to understand what is the third veto, you first try to understand what is mentioned in Article 111. Under Article 111, three options are mentioned which president must exercise whenever a bill is presented to the president. So the three options were, the first is to give his assent, to withhold his assent, and to return the bill. But under Article 111, there is nowhere where it is mentioned that the president must give his assent or withhold his assent or return the bill in how many days. I mean, under Article 111, no time period is mentioned that in how many days the president should use the powers under Article 111. So under Article 111, there is no time period mentioned that in how many days the president should take action on a bill. So it means president can take benefit of this particular thing because no time period is mentioned. So whenever a bill is presented to the president can take benefit of this provision, and the president can keep the bill pending. So whenever the president takes no action on the bill, action means these three options. So whenever the president takes no action on the bill, it means the bill is pending. And whenever the president does this, we can call this as pocket veto of the president. So pocket veto of the president means president is taking no action on the bill. Okay. So I hope these three powers are clear. So the president has three veto powers, and the first veto power is absolute veto. Now I can write at one place. See, the first veto power of the president is absolute veto. In absolute veto, president is saying no, I am not going to sign the bill, and with this the bill ends. The second is suspensive veto. Suspensive veto means the president has returned the bill, but in the second instance he is bound to give his signature. So once the bill is returned, then in the second instance he must give his signature to this bill. And the third veto power is the pocket veto. Pocket veto means when the president has exercised, when the president has not exercised any option on the bill. So it means under pocket veto, the bill is pending. And remember, there is no time period. I mean, for how many days the bill can be kept pending? No, there is no particular time. The bill can be in the pending state for indefinite period. There is no particular time involved. Okay, so I think we are done with the veto power of the president, and the famous example for the veto power of the president is of the President Gyani Zail Singh. The President Gyani Zail Singh in 1986 exercised pocket veto on Post Office Amendment Bill, which was passed by Rajiv Gandhi government. That particular bill tried to curtail the freedom of press, and that is why the President of India at that time exercised pocket veto, and that bill was pending for 3 years. When the new government came and the new president came, so the new government asked the president to return the bill. So that particular bill was returned after 3 years. So for 3 years, that bill was kept pending, and no action was taken for 3 years. So we cannot say that what is the time period or what is the maximum time period for a particular bill. I mean, the bill can be kept pending for indefinite period. There is no time period involved. Okay, so we are done with the veto power of the president, and now we can start with the second power of the president. The second power of the president is the ordinance making power of the president. Okay, the second power of the president is the ordinance making power of the president. Now remember, article is important. Under Article 123, the ordinance making power of the president is mentioned. So you have to remember the article as well. It is Article 123. And we are not going to discuss the ordinance making power of the governor separately. You just have to remember that what is the article number of the ordinance power of the governor. See, both the president and governor have the authority to issue ordinance. The president can issue ordinance under Article 123, and the governor can issue an ordinance under Article 213. So here we can simply write that Article 213 is the ordinance making power of the governor. The ordinance making power of the governor is under Article 213. So we are not going to discuss the ordinance power of the governor separately. Today we will discuss the ordinance making power of the president and what all points we are going to discuss under Article 123. All those points are applicable to the powers of the governor. Okay. So first we will start with what is the meaning of the word ordinance. So remember, ordinance means temporary law. Remember, ordinance is a kind of law, but it is a law which is temporary in nature. It means after some time, ordinance is going to end. See, permanent laws are made by parliament. Now here, the president is trying to make laws. When the president is trying to make laws, we cannot consider those laws as permanent in nature. The permanent laws are made by parliament, but still president is trying to make law. So here the laws made by the president are temporary in nature and they can become permanent only when the parliament gives approval. So without the approval of parliament, ordinance remains temporary. Only when it receives the approval of parliament, then it can be converted to a permanent law. But initially it is an ordinary law. So first we have to discuss that what is the meaning of the word ordinance. So ordinance means temporary law. Now a question arises, for how long it is going to remain temporary? I mean, what is the maximum life of an ordinance? This will be discussed but after some time. But let me tell you, the maximum life of an ordinance is 6 months and 6 weeks, which together makes 7.5 months. So the maximum life of an ordinance is 7.5 months. Now what is the logic behind calling it, I mean, what is the logic behind saying 7.5 months? Why not 8 months? Why not 9 months? Why 7.5 months is the maximum life period, maximum time period of an ordinance? This will be discussed but after some time. But first we have to understand that why the president is trying to issue an ordinance. See, the primary function, function of the parliament is to make laws. So ideally it is the parliament which is going to make laws. If there is parliament to make laws, then why the president is trying to make laws? The question comes, what is the need to issue an ordinance? So first we will discuss that what are the conditions which compel the president to issue an ordinance. Okay, so remember, first we are going to discuss the reason for promulgating an ordinance. Reason or condition. So what are the conditions for promulgating an ordinance or for issuing an ordinance? So as per the constitution, there are two conditions for issuing an ordinance and these two conditions should be satisfied, okay, at the same time. So what are these two conditions for issuing an ordinance? Now remember, the first condition is, see, we can understand the first condition by understanding that parliament consists of 3, Lok Sabha, Rajya Sabha and president. And now you try to understand, in a year, parliament has 3 sessions. So in a particular year, there are total 3 sessions of parliament. The first session starts from February and ends. Okay, this is called budget session. The second session starts from July and continues till September. Then third session is from November to December. Now you tell me, what is the time gap between the first 2 sessions? It is of 1 month and it is the month of June. In the month of June, parliament is not in session. Similarly, in the month of October, the parliament is not in session, and similarly in the month of June, parliament is not in session. So the month of June, October and January, these 3 months are that time during which the parliament is not in session. So now remember, parliament is not in session. It means Lok Sabha is absent and Rajya Sabha is absent. Now you tell me, what will happen if the parliament is not in session and there is some urgent work? I mean, the government requires a law. The government urgently needs a law, but those who makes the law are not in session. So what will happen in this case? So whenever the condition arises where the government needs to make a law in urgent and there is no one to make the law, so in this case, the government can ask the president to issue an ordinance. Okay, so whenever the parliament is not in session and the government wants to make a law and it is urgent for the government to make the law, See, it is possible to summon both the houses of parliament. See, in the month of June, the parliament is not in session, but still we can summon the parliament if there is some kind of urgency. But the fact is that in parliament, there are members from all over the country. So it will take time. And suppose the work is urgent, you urgently need a law. So you cannot expect all the members of parliament to assemble on this particular day. It might take time because they are coming from all over the country. Some might be even outside the country. So whenever the work is urgent, okay, in this case, instead of summoning the parliament, we can simply ask the president that you do one thing. Both the house of parliament are not in session. You promulgate an ordinance. So this is the second condition of promulgating an ordinance. The first condition for promulgating an ordinance is that the parliament is not in session. And the second condition is the work is urgent. And these two conditions should be satisfied at the same time. And there is one more thing. Suppose one house of the parliament is in session and the another house is not in session, or vice versa. Whenever this situation comes that both the houses of parliament are not in session or either house of the parliament is not in session, then remember, in all these cases, an ordinance can be issued. Okay, so parliament is not in session and at the same time, the government is facing some urgency and the government needs a law. Now, these two conditions should be satisfied together. Why I am saying so? See, suppose the parliament is not in session, but the work is not urgent. Parliament is not in session and the work that you have is not urgent in nature. So you can simply wait for 2-3 months once the parliament assemble and then you can make a law. So just because parliament is not in session, you cannot pass an ordinance. The work should be urgent. And suppose the work is urgent, but the parliament is in session. It doesn't matter. However, the work is urgent, you still have to pass the bill through the parliament. You cannot take the route of ordinance just because the work was urgent. Okay. So I hope these two conditions are, you understood these two conditions. So what was the first condition for promulgating an ordinance? When the parliament is not in session or either house of the house is not in session. The second condition is that the work is urgent and you cannot wait for the parliament to come in session. Then you can issue an ordinance. Okay. So these are the two conditions for issuing an ordinance. Okay. So the second condition, this was the first condition which we have discussed. Now the second condition is that the president is satisfied, that the circumstances exist, which render it necessary for him to take immediate action. Now remember, when I was saying that the work is urgent, that urgent condition is expressed in this way. This is the second condition which I was saying, that the work is urgent and you cannot wait. This is how the constitution says that what will be the kind of urgency. So the answer is, the two conditions for promulgating an ordinance are, first, the parliament is not in session or either house of the parliament is not in session, and the second condition is this, that the work is urgent. But how we are writing the urgent work? We are writing urgency in this way, that the president is satisfied that the circumstances exist that render it necessary for him to take immediate action. So this is called urgency. You have to take action immediately. Such were the circumstances which compelled the president to take immediate action. And remember, when I say the word satisfied, see, here satisfied is mentioned. We are not talking about the personal satisfaction of the president. Okay. Now remember, we are not talking about the personal satisfaction of the president. We are basically talking about the satisfaction of the government, because president is no one who is going to be satisfied personally. Personal satisfaction of president doesn't matter. It is always about the satisfaction of the government. Now, two things that you have to remember. when it comes to satisfaction. Now there is a case. The case is known as RC Cooper case. In RC Cooper case, the Supreme Court said that the satisfaction of president is subject to judicial review. I mean, the president's decision to promulgate an ordinance can be subjected to judicial review on the ground that the president tried to prorogue both the House of Parliament. See, to prorogue both the House of Parliament is with the president. See, in the month of in the month of February, the Parliament is summoned. Okay, and in the month of February, it is the prorogation. Prorogation means to terminate a session of the Parliament. Okay. See, if you are saying that are these classes enough for the CDS examination, now remember, the level that we are teaching at present is will be able to cover even the CDS examination. Okay, and I'm not talking only about the CDS examination. Even if you are preparing for the civil service preliminary examination, okay, I'm not talking about the mains examination of civil service, but if you're studying for the prelims of civil service, then also this content is going to help you. Okay, see, I am concerned with the polity. Okay, so as far as polity is concerned, I try to ensure that majority of the points mentioned in the M. Lakshmikant are covered in my class. See, because for me, the best book for civil service preliminary examination, not for mains, but the best book for civil service prelims is M. Lakshmikant. Okay. However, the nature of exam is changing. Sometimes questions are more analytical in nature, which are beyond the reach of M. Lakshmikant, but still, if you have the good knowledge of M. Lakshmikant book, then you will be able to cover the polity section of prelims of UPSC. Okay, so I try to focus that majority of the points of M. Lakshmikant are covered in my class. Okay, so I can just assure you that so far these prelims of civil service concerned, my notes are going to help you. But as far as CDS concerned, remember, CDS is way below than the civil service. Okay, civil service is the top level where you can find the toughest question coming out from each and every subject. But when it comes to CDS examination, you cannot compare the level of CDS with the civil service examination. So obviously, my content is going to help you in in CDS examination. So be it ND or CDS, this content is going to help you. Okay, and you don't think that I'm trying to exaggerate something. If you have continuously attended my class, then you must have observed that I'm not just simply trying to teach one-liner facts. I'm trying to explain you the concept related to particular thing. Okay, so let me let me resume this. So in RC Cooper case, the Supreme Court held that the satisfaction of the president is subject to judicial review. It means the decision of the president to prorogue the session of the parliament can be questioned on the ground that president has deliberately prorogued the session of parliament in order to promulgate an ordinance on such a subject which was otherwise controversial in nature. Had the government passed such a law through the parliament, it would have met with resistance. But what government did? Government said to the president that you do one thing, you prorogue the parliament. Now once the parliament is prorogued, it means now parliament is not in session. Once the parliament is not in session, now the government has the excuse. Now the government will say, we have some urgent work and the parliament is not in session. But the fact was, the parliament was not in session because the government asked the president to do so. So this particular reason for issuing an ordinance can be considered as malified intention. So the satisfaction of president can be questioned on the ground of judicial review. The satisfaction of the president is subject to judicial review on the ground of malified intention. Here, malified intention means the decision of the president to prorogue the parliament was not good. You deliberately tried to prorogue the parliament so that you can pass a law or you can pass an ordinance on a controversial subject, which would have met with resistance in the parliament. Okay. So I hope RC Cooper case is clear that the satisfaction of president is subject to judicial review on the ground of malified intention. It means the intention of promulgating an ordinance was not good. Now, this was an RC Cooper case which happened in 1970. So in 1970, the Supreme Court said this. Now remember, the government did not appreciate the RC Cooper judgment. So what government tried to do? Government nullified the judgment of RC Cooper because government do not want that the satisfaction of president is questioned in the court on the ground of malafide intention. Okay, so what happened? By the 38th Constitutional Amendment Act of 1975, the government declared that the satisfaction of the president is beyond judicial review. Satisfaction of president is beyond judicial review. It means the decision of the government, it means the decision of the president to promulgate an ordinance cannot be questioned in the court on the ground that the intention of promulgating an ordinance was filled with malafide. No, you cannot question the satisfaction of president, because the satisfaction of president means the satisfaction of the government, and government does not want that someone is questioning that why you issued the ordinance. Government do not want that the court should ask that why you issued the ordinance. Okay, so this was done by the 30th Amendment Act. Now what happened with 30th Amendment Act was reverted by the 44th Amendment Act. So by the 44th Amendment, the constitution was amended, and it was said that the satisfaction of the president is subject to judicial review. So what 38th Amendment tried to do? 38th Amendment ensured that the satisfaction of the president cannot be questioned in any court. It means if the government has issued an ordinance, then the court has no authority to question. But 38th Amendment tried to nullify the judgment, but it was reverted to its original state by the 44th Amendment Act of 1978. Okay, so when it comes to the satisfaction of president, you have to remember R.C. Cooper case and the changes introduced by 38th Amendment Act, and again reverted to its original position by the 44th Amendment Act of 1978. Okay. So I hope the ordinance of the president, the condition for promulgating an ordinance, I hope you understood those two conditions. So we are done with the conditions for promulgating an ordinance, and now we can start that what is the maximum life of an ordinance. We all know ordinance is temporary in nature. Now the question comes, for how long ordinance can remain in existence? How long ordinance survives? See, so what will be the maximum life of an ordinance? The maximum life of an ordinance is 6 months plus 6 weeks. Okay, so together it makes 7.5 months. Okay, so this is the final answer, that the maximum life of an ordinance is 7.5 months. Now what is the logic of dividing 7.5 into 6 months and 6 weeks? We could have expressed 7.5 months in another way. Why to express 7.5 months in this way, 6 months and 6 weeks? Why not 7 months plus 2 weeks? Why we are saying 6 months and 6 weeks? So what is the logic behind 6 months and 6 weeks? Let us understand. See, why 6 months? Under Article 85, sessions of parliament is mentioned. Okay. The sessions of parliament is mentioned under Article 85. Now under Article 85, it is mentioned that the maximum gap between the two sessions of parliament cannot be of more than 6 months. It means parliament must meet at least twice in a year. So according to constitution, the parliament can remain, according to constitution, the maximum gap between the two sessions of parliament can be for 6 months. So for those 6 months, we can issue an ordinance. The ordinance can remain in existence for 6 months, because for 6 months, parliament is not going to come in session. So the maximum time period between two sessions of parliament is 6 months. Now what about 6 weeks? After 6 months, the constitution warrants that parliament must assemble, the parliament must come in session. So remember, when the parliament comes to session, from that day, within 6 weeks, the parliament must approve an ordinance. So the ordinance should be placed before the parliament once it assembles. Okay, so suppose parliament assembled. Now from this day, within 6 weeks, the parliament must give its approval to the ordinance. Only when the parliament approves the ordinance will become a permanent law. So there are chances that ordinance will be converted to a permanent law, but this can happen only when the parliament gives its approval, and the time period for the parliament to give its approval is the 6 weeks period. Okay. So 6 week means time period. It is the time period within which an ordinance must be placed before the parliament. So can we say that 6 periods is the time period for the parliament to take action? Okay, so I hope the logic for 6 months and 6 weeks is clear. Why 6 months? Because the maximum time period for which parliament cannot remain in session is 6 months. Okay, after 6 months, the constitution expects parliament to come, and once parliament comes to the session, within 6 weeks, parliament must approve an ordinance. If the parliament approves the ordinance, then the ordinance will become a law. If the parliament does not take any action on the ordinance, then the ordinance end after 6 weeks. Okay, and if the parliament disapproves the ordinance, then ordinance is going to end once it receives disapproval of the parliament. So I hope this particular point is clear, that why we are saying that the maximum life of an ordinance is 6 months and 6 weeks. So we can write here that 6 months is the maximum time period or maximum gap between two sessions of parliament. This is the maximum time period. So I hope this is clear, that what is the maximum time period, I mean what is the maximum life of an ordinance. Now one more thing, remember, if someone asks that what are the powers of the ordinance, I mean what all government can do by an ordinance. So through an ordinance, the government can do all those works or all those things which were done by the parliament. So it means the parliament can see, remember, an ordinance can make laws on all those subjects on which parliament is authorized to make law. Suppose parliament is not authorized to make law on this matter, then the same restrictions are imposed on an ordinance. If the parliament if the parliament cannot make a law on this subject, then ordinance is also subject to same limitation. Ordinance also cannot make law on that subject. If the parliament can make law on this subject, then ordinance can also make law on this subject. So the power of an ordinance are coextensive with the power of the parliament. What all parliament can do, ordinance can also do. But there is one difference, and the difference is only parliament can amend the constitution. It is not possible for an ordinance to amend the constitution. This is one of the main limitation upon the ordinance. See, one limitation is that ordinance is temporary in nature, and the law made by the parliament is permanent in nature. There is one difference between the temporary and permanent. Now, this was the first difference, and the second difference is that only parliament has the authority to amend the constitution. We cannot amend the constitution by an ordinance. Why? The reason is simple. For amending the constitution, parliament uses the constituent power of the parliament. See, for amending the constitution, parliament exercises the constituent power of the parliament under article 368. So it is the constituent power of the parliament to amend the constitution. But remember, ordinance is the legislative power of the president. For amending the constitution, you require the constituent power. And for ordinance, it is simply mentioned that ordinance is the legislative power of the president. So the nature of power is different. Ordinance is legislative in nature, whereas for amending the constitution, you require constituent power. Okay, so which is only with the parliament. Other than parliament, there is no one who can amend the constitution. Okay, yes, some informal amendments are done by the judiciary, because judiciary is the interpreter of the constitution. So some informal amendments are done by the judiciary. When judiciary says that this particular fundamental right, this particular right is also considered as fundamental right. For example, Supreme Court in KS Puttaswamy case held that right to privacy is a fundamental right under Article 21. So Article 368 was not used to mention right to privacy under Article 21. No. right to privacy is still not mentioned under Article 21, but still right to privacy is considered as a fundamental right under Article 21. So it means this was an informal amendment. Now we consider right to privacy as fundamental right, but nowhere in the constitution it is mentioned that right to privacy exists. So these are some informal amendment done by the judiciary when they change the meaning of a particular thing. For example, under Article 21, I don't know whether we discussed about the procedure established by law and due process of law. Remember, at present, under Article 21, it is mentioned procedure established by law. But the Supreme Court changed the meaning of procedure established by law. And the Supreme Court in Menka Gandhi's case said that the procedure established by law basically means due process of law. So the word, the expression remains same, procedure established by law, but the meaning of that expression has been changed by the Supreme Court without introducing an amendment to the Constitution. Similarly, while appointing the judges of Supreme Court, the word consultation is used. It means the President is supposed to consult the judges of Supreme Court and High Court while appointing a particular judge. So remember, ideally, according to the Constitution, the President is supposed to consult the members of Judiciary while appointing judges of Supreme Court and High Court. But it was in the second judge's case where Supreme Court changed the meaning of the word consultation. In second judge's case of 1993, Supreme Court held that the word consultation means concurrence. So the word is consultation at present, but the meaning of the word consultation has changed to concurrence. It means the advice given by the judiciary is binding on the president. So these are the informal amendments done by the judiciary, and these amendments are done even without applying the procedure of Article 368. So judiciary can do informal amendments, but as far as proper formal amendments are considered, only Parliament has the authority to amend the Constitution under Article 368. Through an ordinance, we cannot amend the Constitution. That's a limitation imposed upon the ordinance. Okay, so what are the limitations imposed upon the ordinance? The first limitation is that the ordinance is temporary in nature, whereas the law made by the Parliament is permanent in nature. This is the first limitation. The second limitation is that only the Parliament can amend the Constitution, because for amending the Constitution, constituent power of the Parliament is required, whereas the ordinance is legislative power of the President, and through the legislative power we cannot amend the Constitution. Okay, so this could be a rationale for why we cannot amend the Constitution with the help of an ordinance. Okay, so with this, the ordinance making power of the President is over. So all the relevant portion of the ordinance making power of the President is completed. Okay, now the third power of the President is the pardoning power of the President. Now remember, pardoning power of the President is the executive power of the President. Okay, according to Supreme Court, whenever President pardons any convict or any person, President exercising the pardoning power can be considered as the executive power of the President and not as the judicial power of the President, because we all know President possesses executive power as well as judicial power. But there might be confusion that if President is trying to pardon someone, then it might be seen as the President trying to interfere with the judicial process. No, the President is not trying to interfere with the judicial process. It is simply an extra option available to the convict, because errors are possible even on the side of judiciary. Even judges can commit an error. So because we live in a society where the life of its member is on the highest pedestal, so we cannot treat the action by the state, action of the state taking life of an individual is considered serious. So whenever a state tries to deprive someone of its life, then particular action of the state is considered serious, and that is why there should be recourse available with the convict. So that is why if there is a error on the side of judiciary, then the person can approach the President. Okay, but President do not sit as the court of appeal. Okay, and President is not going to overturn the judgment of the court. What the court has said has said. The judicial record is not going to be altered by the pardoning power of the President. The judicial order remains intact. If the judiciary has ordered that person to life imprisonment or death penalty, then the judicial order remains intact. The President is not going to alter the judicial order, but simply the President is giving the relief to the convict, but the judicial order remains intact. Okay, but all these things should be discussed under the topic pardoning power of the President. And moreover, such kind of analytical question do not come in your examination. I mean, what is the rationale of giving pardoning power to the president? Many times students ask this question from me that why we have given a pardoning power to the president. I mean, what is the need of giving such a power to the president when already Supreme Court and High Court exist? Why to give president power? Sorry, why to give this power to the president? Is there any intention of placing president above the judiciary? No, there is no such intention. The proper rationale of this particular thing is mentioned in law book. Okay, I mean, there's one book called MPGen. In MPGen, there is a good rationale that why the president should be given the power to pardon. Okay, but we all, we are not supposed to discuss all these things while we are preparing for these examinations, CDS, NDA, or defense. I mean, defense, SSC, railway. These things are not asked in our examinations, so that is why there is no need to understand. When it comes to civil service examination, then yes, such analytical questions are required. Okay, I mean, the answer to such questions are required. Okay, but I mean, in the next class, tomorrow we are going to meet at the same time, 8:30 to 9:30, and tomorrow we will discuss the pardoning power of the president. Okay, so tomorrow we will study the parliament. Tomorrow we will study the pardoning power of the president, and then after we will start with the topic governor. So tomorrow the main topic will be the governor, and we will also complete the pardoning power of the president. Okay, so bye everyone. We'll meet tomorrow. Thank you everyone.